Assalamualaikum and greetings. We are Dechuds from CFF115 Diploma of Animation. We will be discussing about Katy Perry versus Katy Perry, a 17-year-long legal battle. Catherine Elizabeth Hudson, who is also known as Katy Perry, is an American singer, songwriter, and TV personality born on October 25, 1984. You may also know her from her songs California Girls, Teenage Dream, Firework, E.T., and Last Friday Night. She was one of the biggest influences on pop music, next to Lady Gaga in the 2000s and early 2010s. She naturally has a lot of controversies and scandals under her belt within her 25 years of career. The most infamous ones being her sexual assault allegations by Ruby Rose and multiple other women, and also her forceful non-consensual kiss from a random contestant on American Idol during the 16th season in 2018. However, our pop star's reputation was at risk, befallen by misfortune when an existing label with Katy Perry made its debut in 2008. Katy Jane Taylor is an Australian fashion designer born on the 30th of December 1980. She submitted her trademark as Katy Perry in September 2018, which was formally approved in the Australian Official Journal of Trademarks on 29th of January 2009. In June 2009, she launched the Katy Perry Studio in Mosman, a suburb of Sydney.
From 2008, Katy sold her clothing line at the local market scenes, social media accounts, and websites with the Katy Perry brand name. During the planning of Hello Katy World Tour by pop singer Katy Perry's team, she sold her merchandise to her fans while simultaneously coinciding with Katy Perry's start of a clothing line business. The pop singer worries the clothes brand name would confuse her fans that were attending her tour to buy her merch, hence pressuring the fashion designer to change her brand name. The singer, Katy Perry, sent a lawyer based in Brisbane from a firm specializing in intellectual property rights to be applied to IP Australia to oppose fashion designer Katy Perry's new trademark on the basis of similar naming.
On 29th of June 2009, the fashion designer posted a video that is meant to reach out to the pop singer as a personal video on YouTube to seek peace, willing to put behind the lawyers and legal battle. She wished them both to pursue their individual careers and wished the singer well for her upcoming Australian tour. In October 2019, the fashion designer initiated legal proceedings against Katy Perry's label for trademark infringement against her own brand line. Katy Perry said the singer had violated, disrespected, and ignored the rights of her trademark, despite her fashion brand line trademark being registered as an Australian trademark. Even knowing those rights, the singer has been using her locally unregistered trademark on all her goods, including merchandise and clothing to local fans. The fashion designer argued that the singer's trademark is too similar, almost identical, adding to the fact that the Katy Perry fashion label is registered in Class 25 for clothes, thus the singer had directly infringed her registered trademark.
In April 2023, the Federal Court of Australia published its decision in which it found the singer infringed on the fashion designer's Katy Perry trademark in Australia. It was reported that the pop singer and her firms filed their appeal relating to the decision on 14th of June 2023, and the singer won her appeal to the full court of the Federal Court of Australia, with the fashion designer's trademark potentially being cancelled on the 22nd of November 2024. Regardless, after almost 17 years of conflict, in March of 2026, the High Court of Australia defended and sided with Katy, the fashion designer's trademark for her clothing brand, and stating that the pop singer had persistently violated her trademark. The court's majority decision found that Katy's trademark was not likely to harm nor take over the singer's own brand to the point of global confusion, and the costs were awarded to the designer.
So, what can we learn from this case? As artists, we should make a proper registration of our own trademarks to protect our creations and rights. This case reinforces a core of principle of Australian trademark law, which is first in time, first in rights, if properly registered. Even global fame cannot interfere with one's official and valid early registered trademark. While reputation can defeat a trademark, it must relate to the same or closely related field. In this case, music fame does not equate to automatic clothing rights. However, many assume you can freely use your own name in business, but using your own name is not a defense, as personal names can infringe registered trademarks, and commercial use must still comply with trademark law. Brand expansion can create legal risk since Katy Perry expanded into fashion merchandise. So, what can we do for our business? Well, we must register our trademark early, conduct proper clearance searches, reassess risk before expanding your brand, and don't rely on reputation alone. We must acknowledge the safety of our labels nonetheless.
In conclusion of this case study, we must know our rights and fight against malicious entities that try to bring us down, especially when it is regards to the law. In other words, to stand our ground and fight for justice. This highly applies to small business to be protected, not only by the business itself, but the community that surrounds them. They will be the biggest factor of your business growth.
We shouldn't be afraid to voice out our concerns and call out the entity that harms us. No matter what you do or study in, we should all educate ourselves and acknowledge the law to avoid being involved into unfortunate events such as trademark infringements. It's never wrong to overthink about our surroundings if it's for our own safety. Be creative, be smart, be vigilant, be brave. Thank you for watching, and we hope you learned something as much as we did.
I'm like, hey, what's up?